Hi, my name is Eric Olson, Director of HELPS. I want to talk about the issue, can a judgment collector from one state garnish wages from a person who works and lives in another state? This doesn't happen very often. We don't see it happen very often because most of our clients are seniors, they're not working. But I did have a client today call. I believe she enrolled in HELPS, and she was making a little bit money from a job, and her employer received a writ of garnishment, and she asked me to contact the employer, and so I forwarded him some information. So I'll give you the example, not this case, but a general example. So let's say you lived in Arizona and you got sued for a credit card and you owe $5,000. Okay. They get a judgment in Maricopa County, Phoenix, Arizona. And then you move to Nevada or wherever, any other state. And then you go to work for someone different. And now that judgment creditor in Arizona, that law firm or whatever, they find out where you're working, and they prepare a writ of garnishment and they send it to your new employer. Now, the attorney can prepare a writ of garnishment himself. It's generally in states have different rules, but usually attorneys can do that. He sends it to your new employer. What's your new employer going to do? Okay. A judgment is effective in the state where a person lives. The only way it can be enforced in another state is if the judgment is domesticated or transferred to that new state where a person lives. There's a few exceptions, but it needs to be transferred. There's a process for doing that. It costs money to do that. You have to file a paper in the court in the new state with a copy of the certified copy of that judgment from Arizona, and then they have to serve you, and the time period has to run. Now, as a practical matter, judgment collectors from one state will not transfer a judgment into a different state for a lot of different reasons. It costs a lot of money, it's a headache, and it's just not worth it for them to do it. Especially for our clients, many of whom are on Social Security and a pension, their income's protected anyway. They can't get anything from it, so it's a waste. So I think I want to read you something from a site that gives advice to debt collectors on this issue, and it's kind of interesting. It says, if you attempt to serve a writ of garnishment on an out-of-state employer, technically the employer may not have to honor it. That's right. That's right. But then certain states do make exceptions for certain debts, such as federal taxes, student loans, alimony, and child support. Well, actually, the IRS garnishes for taxes, not a judgment creditor. But for, and student loans usually don't sue people. They try to take it out of your Social Security. But for alimony and child support, yeah, a state can garnish another state. They don't have to transfer that alimony or child support judgment to try to garnish money from someone employed in another state. Doesn't happen for our clients, hardly ever. Okay. However, they may still send the writ of garnishment to the employer, who may or may not respond. Employers are often accustomed to dealing with the wage garnishment orders. So they see the garnishment, they don't even look at the top to see where it came from, to see that it came from a completely different state. They just see a garnishment, oh, we got to honor it. Instead of involving themselves in legal complications, the employer may simply honor the garnishment and send you the money, assuming the debtor raises no legal objections. Okay, so, and that probably happens a lot, and that's why they do this. They just send the garnishment to a different employer in a different state, hoping that that employer will go ahead and honor that garnishment, even though it is technically not legally enforceable, because because that judgment has not been transferred to that state. Now, I see this happen occasionally with banks, bank garnishments. We don't see with our clients, because for seniors who get Social Security or federal benefits, Twice the amount of the Social Security that's placed in their bank account is automatically protected from garnishment. Twice the amount each month is protected automatically from garnishment, no matter what monies are in there, where they came from. So if you get $1,500 in Social Security, $3,000 in your account is protected automatically. A bank can read the code where the money came from. They just rip up the garnishment and throw it away. So if you had a bank in, let's say you had a bank in Nevada, and you were a senior citizen or whatever, and they sent a writ of garnishment on your bank. Does that bank have to pay that writ of garnishment? Well, they might have to if that bank has branches in the state where the garnishment came from. So if it's like Wells Fargo, U.S. Bank, any of these big banks that have multi-state branches, yeah, they probably are going to honor it. But if it's a bank where they only have one or two branches, banks, and they're only in your state and not in that other state, technically, they're not supposed to honor that garnishment. Now, they might, out of ignorance, and the same goes with credit unions. I just don't see it happening. It's kind of an odd case, but it's something maybe you're interested in. So the bottom line is that normally for a judgment to be enforced in a different state, it has to be transferred to that state, with few exceptions. But most of the time, our clients don't need to worry about this because they're receiving Social Security and a pension or disability, which is protected anyway. So my name is Eric Olson again. I'm the director of HELPS. What we do is we represent seniors nationwide who have debt they can't afford to pay as their attorney, so they don't have to deal with collectors again. Under a federal law called the Fair Debt Collection Practices Act, if a person is represented by an attorney, debt collectors have to leave them alone. They can't call them or send them letters in the mail anymore. And that's what, so when people enroll with HELPS, we send a letter to your collectors and they're going to stop contacting you. And then we represent our clients ongoing years into the future. So they ever have a question or concern or worry, they can always call us, no matter how often. And we also educate our clients how they can maintain their financial independence. You can learn more about HELPS by visiting our website, www.helpsishere.org, or you can call us toll free at 855-HELPS-US. We would never turn anyone away that needs the help we provide. And hopefully you like this video. Kind of interesting, I think, in some ways. And but it may never apply to you, so I wouldn't get too worried about it. But if you like this, we'd ask you to click the button down here so you can get other updated emails or YouTube notices from HELPS. Have a great day.